AHLA is pleased to present this special series highlighting the top 10 health law issues of 2024, where we bring together thought leaders from across the health law field to discuss the major trends and developments of the year. Support for AHLA in this series is provided by PYA, which helps clients find value in the complex challenges related to mergers and acquisitions, clinical integrations, regulatory compliance, business valuations and fair market value assessments, and tax and assurance. For more information, visit pyapc.com.
Hi, I'm Carol Carden. I'm a principal with PYA. Thanks for joining us today. This is the 6th episode in the AHLA Top 10 podcast series, and today we're talking about the reproductive health update for 2024. I'm joined today by Jody Joyner with Tenet Healthcare and Gina Bertolini with K&L Gates. So thanks for joining me, ladies. I read your article a couple of times because it's obviously so much going on in this area still. Doesn't look like anything's calmed down in the year or so since the Dobbs decision. So I was just wondering, from your all's perspective, and Gina, I'll let you start, even since this article's been published, it seems like every day we're seeing something in the news that is being impacted by the Dobbs decision. Have things changed even since this article has been published earlier this year?
Yes, thank you, Carol, for that question. There has been a lot happening even since our article was published. And in fact, as Jody and I prepared for today, I think one of the challenges we had was really discerning, what to cover and what to leave out, because there's so much happening. And if we think about that, there's both the federal and state levels where there are things happening related to the Dobbs decision and access to abortion and reproductive health care. There's really a lot to talk about. I'll focus right away on what's happening at the federal level, because it's really actually quite fortuitous, the timing of this recording, which is January 24th. On January 22nd, just 2 days ago, was the anniversary of the Roe versus Wade decision. And the Biden administration used that anniversary as an occasion to demonstrate its continued commitment to providing access to reproductive health care, and including access to safe abortion and access to contraceptives and birth control, by really organizing several efforts at the federal level. So I'll talk about what some of those are that just occurred in the last couple of days. First, President Biden issued a statement reiterating his and Vice President Harris's commitment to providing access to safe health care for women, including reproductive health care, including access to contraceptives. And on that day, President Biden convened the White House Task Force on Reproductive Health Care Access, and his press secretary had quite a lengthy press conference to talk about all the initiatives that the Biden administration has taken and is taking. Also on that day, Secretary Becerra issued a letter regarding access to contraceptives directed to federal healthcare plans and private payers, and reiterating what the law says around access to contraceptives. Also that day, HHS issued a statement saying that CMS, the Centers for Medicare and Medicaid Services, would launch a series of actions to educate the public on their rights to emergency medical care, as well as initiatives to support hospitals in complying with EMTALA, which is the Emergency Medical Treatment and Labor Act. Jody and I will talk a lot about that today. We'll call that's EMTALA, known as EMTALA. And there's been a lot of focus on that at the federal level. So there will be these renewed, educational efforts rolled out by CMS. But also, as many of our listeners will know, there is a case pending currently. It's a case out of Idaho that challenges Idaho's restrictive state laws that conflict with EMTALA's requirements when an emergency medical condition exists. Jody is going to talk more about that, so I'm just touching upon it briefly here. But one thing I will mention is that since our article was released on January 5th, the U.S. Supreme Court, actually I should say that I don't know when the article was released, that was earlier in January, but on January 5th, the U.S. Supreme Court issued cert to hear that case. And so we expect to hear that during the April oral argument session. Also at the federal level, the Department of Justice filed a statement of interest, not a lawsuit, but a statement of interest in 2 lawsuits against the Alabama Attorney General that have been consolidated in Alabama District Court, and they pertain to the right to interstate travel. And I'll talk more about that in a little bit. There are also continuing efforts to protect the privacy of healthcare information through the Office for Civil Rights proposed rule, which is still pending, that would restrict the use and disclosure of reproductive health care. There's also activity happening at the with the Federal Trade Commission, FTC, and just last week, actually, there was a letter written to the FTC asking them to initiate an enforcement action against Google for failing to protect location information, including information about people who access reproductive health care or visit abortion clinics. Also, as we reported in our article, the Supreme Court in December granted FDA's petition for cert in the mifepristone case. Mifepristone is often referred to as the abortion pill. So that's the case that was brought by several healthcare providers challenging FDA's approval and several FDA actions through the 2000s regarding the safety and efficacy of mifepristone. We expect that that will be heard by the Supreme Court this term and likely a decision by June. And then lastly, I'll just say there are several congressional bills pending regarding abortion and access to abortion. There are 3 bills pending that would actually ban abortion, and there's one that would codify Roe versus Wade. So there's no shortage of activity. We do expect 2024 to be a very busy year, both at the state and federal levels.
Oh, wow. When you said a lot had happened since the article was published, you were not kidding.
That's right.
So Jody, Gina had mentioned the EMTALA case out of Idaho, but I also understand in the state of Texas, there's been some challenge to EMTALA guidance. And since you practice in Texas, could you give us a little more information on that situation?
Yes. So the HHS through CMS provided the guidance on EMTALA right after the Dobbs opinion, essentially saying that the EMTALA statute preempts any state abortion ban that is inconsistent with the EMTALA provisions that mandate emergency medical care. So it's and they got into some specific scenarios there. And the initial plan was they looked at situations where there was no exception under the state ban, or if the state ban had such a narrow definition of emergency that it was more narrow than the EMTALA definition. And in those circumstances, this CMS HHS EMTALA memo said EMTALA preempts state law, and the hospitals and physicians have to follow EMTALA, provide stabilizing treatment, even if that stabilizing treatment is an abortion that may otherwise be in violation of state law. Which sounds pretty clear, except that it's not, because one, EMTALA is a civil statute, and most of the state laws that we're talking about regarding abortion are not civil in nature. Many are criminal, and physicians and hospitals who are concerned about criminal liability under the abortion statutes are going to be more concerned about that than they are EMTALA. So that's just kind of the underlying feeling around this. But then you get the politics involved. And so, for example, in Texas, within just a few weeks of the EMTALA memo coming out, the Texas Attorney General filed a complaint in the Northern District of Texas trying to enjoin enforcement of the EMTALA memo. And that was granted by the trial court, and also that granting of that was affirmed by the Fifth Circuit Court of Appeals. So right now, Texas is the only state where the EMTALA memo doesn't have to be followed. So that's where we stand in Texas, in the Wild West. We're doing our own thing out here. In Idaho, you have a similar scenario where you have a complaint related to the EMTALA memo versus the state abortion ban. But there, it was the U.S. Department of Justice that filed the complaint. So it was kind of the opposite scenario. They sought an injunction prohibiting the enforcement of the state abortion statute because of the conflict with EMTALA, and that EMTALA mandates the emergency care. So just on the emergency care provision. So if there's EMTALA mandated emergency care that would otherwise violate that statute, they wanted that enjoined so that the hospitals and physicians could provide that EMTALA mandated emergency care. So that was what was filed in Idaho. And in that one, the court also sided with the plaintiff, but in this case, that was the government. So it was the opposite holding as in Texas, in that case, they said, no, yep, you're right, we're going to follow EMTALA. So now we have these two opposing opinions in this about whether or not to follow EMTALA, whether or not EMTALA preempts state law. So the Idaho case was affirmed by the Ninth Circuit, and now that is going up to the Supreme Court. Supreme Court has accepted cert, and that's going to be argued this spring, probably in April or so. So we're going to see an opinion on that, and that's hopefully going to also provide some guidance in the Texas issue. But those are the EMTALA versus the abortion statute issue. And the reason that this is significant is a little bit, as I mentioned before, you have the issues of the chilling effect of these abortion statutes, because many are criminal, and even the ones that are civil, the bounty laws where Texas, of course, originated that one as well, where they allow citizens to sue other citizens, such as doctors, who perform abortions. So wasn't state enforcement at that point. This was pre-Dobbs. So whatever the statute is that the physicians are concerned about, there is a chilling effect in terms of the physicians not wanting to do anything that's going to put them at risk for liability. And that's a huge concern. So then we have a number of states where there are stories that are coming out where patients are coming in and they're struggling to get abortion care. And it is directly related to this EMTALA versus state statute situation. So Kansas and Missouri, those were the first two states that were that had EMTALA complaints filed against them for this very reason, that in both of those states, the hospitals and physicians refused to provide the abortion care in an emergency because of the state law. And the memo had said, the CMS EMTALA memo had said, state law that doesn't protect you from enforcement of EMTALA.
And Jody, can I just add here, many of our listeners will know this, but some may not, that EMTALA is a very significant issue for hospitals and can result in loss of licensure. Then you also have, in addition to the criminal enforcement that you mentioned that some of the state laws have, there are licensure issues as well for those providers. Some of those laws would result in a loss of a license. Yeah.
That's exactly true. Yeah.
I would imagine both of you advising people across the country, it's got to be tough to keep up with the various state laws. So what are the current statistics in terms of abortion bans, access to abortion care in the various states? Is it split?
Yeah, so I can talk about that just briefly. And I'm look at my notes here to make sure I get it right. So there are 21 states that have abortion bans in place currently. And according to Karine Jean-Pierre, who is the White House press secretary and had the press conference that I mentioned earlier, that's 27 million women of reproductive age living in states with bans. So that's more than 1 out of 3 women in the US living in states where there's a ban. In 2023, there were over 380 state bills proposed that would restrict access to abortion care. Those are proposed bills, so not all passed. And then at the federal level, I'll just mention as well, Jody, I'll talk a little bit more about what's happening with EMTALA and at the state level. But at the federal level, there are 3 abortion bans pending. One is called Life at Conception Act. It's a 0-week ban that would ban abortion outright with no exceptions for rape, incest, or to preserve the life of the mother. There are 2 other bills. One is a 6-week ban, and one would be a 15-week ban proposed by Senator Lindsey Graham out of South Carolina. that 15-week ban would allow states to enact more restrictive laws. So I find it very interesting because one of the fundamental underpinnings of Dobbs was that each state could decide for itself. Obviously that was the significant change from Roe versus Wade. So instead of having this sort of national law or rules regarding the delivery of abortion care, it's now at the state by state basis, but yet there are these laws pending at the congressional level. There is also a law pending that would codify Roe versus Wade. And of course, the Biden administration just on Monday again, requested Congress to pass that law.
Wow, a lot to keep up with. I'm sure a lot of people listening to the podcast probably heard the story towards the end of 2023, where a woman in Texas was seeking a court order granting her an exception to the abortion law. Jody, can you talk a little bit about the impact of that in the Texas market?
Yeah, unfortunately, Texas is in the news a lot in this in this area. In this case, Kate Cox was diagnosed with a condition that her fetus was not viable, had a condition that was not consistent with life outside the womb. So she was wanting to get an abortion, partly because the baby wasn't going to survive, but partly because there were some other potential complications and concerns about future fertility and so forth. And in Texas, the requirement is that there be an emergency, and it has to be an emergency for the mother, and either that her life is at risk or that she's at risk of substantial impairment of a major bodily function. So those are very specific parameters of the law. And again, because the physician was nervous about doing this abortion under the law without having some guidance, they filed a request with the Supreme Court of Texas to say, we want to know if we can do this. We want to have guidance on whether or not this is okay. And the Supreme Court issued an opinion and essentially said, you don't need a court's opinion on this because the statute says all you need is reasonable medical judgment. But the point of it was the physician didn't feel comfortable. The physician felt like there needed to be more guidance on what is an emergency and whether this fits in it. And the Supreme Court actually, in its opinion, helped significantly by making reference to a few things that do clarify, like you don't have to wait until her death is imminent, which is a concern that has been raised by a lot of physicians. But what's interesting is that the Supreme Court basically called on the Texas Medical Board to issue regulations clarifying, providing some guidance for the physicians. And none that did not occur yet. And so now we also, just in the last month or so, we have a private law firm who has filed a petition with the Texas Medical Board urging them to issue regulations, and in fact, providing them with a sample. Here's some regulations we think you could use. And they list, for example, certain emergency conditions that they think would fit the exception. And there would be sort of here's a list including these, but not limited to these, that sort of thing. So it's an interesting approach to get some guidance.
Well, and you have to think from a human standpoint too, how long did that go on with the woman in limbo? Like that would be such a tough position to be in, waiting for a court to make a decision about your care. So exactly.
And in the case in her case, it's unclear whether or not I think the doctor was wanting some guidance, but also I think she ended up going to another state to get her abortion because she was not permitted to do that. And what's interesting is in the EMTALA cases that we were talking about a little bit ago, the woman that went to the Kansas and Missouri hospital because her water had broken and she was only at 17 weeks, so baby wasn't viable. But when you're in a situation like that, there's a high risk that the woman's going to develop sepsis and die. I mean, that's a huge risk. But again, the question was, does she have to be on death's door before somebody can intervene under the law? And that was the question, and that continues to be a concern among many states that are facing these sorts of laws with these emergency exceptions that maybe don't have guidance on what exactly that means. So in that case, that individual also traveled to another state where she could obtain the abortion. So in both cases, they drove hundreds of miles away to obtain the health care that they needed because the state they lived in was not able to provide it.
And I'll just add, I think at the state level, we'll continue to see these kind of cases that really test what is an emergency. And it really will be fascinating to see what happens with the Idaho case in the Supreme Court. And, where the Supreme Court lands in terms of that potential conflict of these state law definitions of emergency as compared to EMTALA's definition of emergency, and how that might then affect the guidance that healthcare providers will have available to them of how to comply. I think we will continue to see these kinds of issues arise at the state level.
Yes, we will. And another really concerning thing about the patient that had initially gone to both Missouri and a Kansas hospital, that she was generally near the Kansas City area. So there's, cross state lines and that sort of thing was fairly easy there. Of course, then she went to Illinois, which is about 300 miles away. But the interesting thing is that about 2 months after this incident, she had a tubal ligation because it was just not safe for her to get pregnant again in the state where she lived. And that's a really unfortunate consequence of these sorts of laws.
This topic is a good segue. Gina, you had made reference in your opening answer to the Alabama case regarding interstate travel. Can you tell us a little bit more about that?
Yes, this is really interesting and yet another, I think, really challenging area. And it really touches on both what's happening at the federal level, but also what may be happening at the state level. This involves a lawsuit brought by two organizations, one called the Yellowhammer Fund and the other West Alabama Women's Center, against the Attorney General of Alabama. So they're Yellowhammer Fund and West Alabama Women's Center versus Marshall are the cases. They've been consolidated in Alabama. These are organizations that seek to really fund and help women access legal out-of-state abortions. And the organizations brought the suit against the Alabama Attorney General because of his statements that he would prosecute anyone who assists residents of Alabama traveling out of state for legal abortions in those other states. The Department of Justice filed a statement of interest in these two lawsuits just late in 2023. And by the way, for those who may not be familiar with the statement of interest, I had to look it up. It is pursuant to federal statute, and it allows the Department of Justice to attend the interest of the United States in any suit pending in federal or state court. So that's what they've done here. The Justice Department's position is that the right to travel from one state to another is firmly embedded in the U.S. Constitution. And what's really interesting is that's a point that Justice Kavanaugh made in his concurrence in the Dobbs decision when he said the question of barring a resident of one state from traveling to another state for a legal abortion is, quote, not especially difficult. And it is no, that is not permissible based on the constitutional right to interstate travel. The Alabama Attorney General is contending that providing assistance within Alabama to a person who seeks an out-of-state abortion would constitute a criminal conspiracy, regardless of whether the abortion is legal in the state where the person is traveling to, if it's illegal, if performed in Alabama. Justice's position, as I mentioned, is that the constitutional right to interstate travel is firmly established in the U.S. Constitution in Article 4, in the 14th Amendment's Privileges and Immunities Clause, and then also by U.S. Supreme Court precedent from some cases, actually from the 1970s, that addressed interstate travel to states where abortion was legal. So sort of around the Roe era, pre-Roe and post-Roe. DOJ contends that prohibiting third-party assistance to traveling to other states, which the Alabama Attorney General apparently intends to do, is not permissible and would severely undercut the right to travel itself. So this would certainly have a chilling effect on access to health care in states where abortion is legal. But one can imagine, the precedent. There are a host of issues where states have determined for themselves what may or may not be legal. Marijuana is a good example. Gambling is another example. I'm pretty sure prostitution is still legal in one of our states. And I've never heard of an attorney general seeking to prosecute an individual of a state who traveled to another state to engage in behavior that's legal in that state. So I think the precedent here is significant. The case, it was set for oral argument on the Alabama Attorney General's motion to dismiss. It was set for October 31st. And this is really interesting as well. The court actually canceled the hearing, said it would reschedule it. And when asked just recently, there was an oral inquiry when the oral argument would be set. The court responded by saying that it needed to learn more about the issues before it could set oral argument, and that it would set oral argument when it could do that. So I think it recognizes the significance of this issue. So we will continue to watch that. And I think there's great impact, in other states there as well.
And one last area I'd like to touch on in our time that we have left is issues around privacy. So I understand there's been an FTC complaint regarding Google. Can you tell us a little bit more about that? Because privacy showing up in the news in a lot of contexts right now.
That's right.
Not the least of which is healthcare information.
Yes, that's a great point. Privacy is a really significant issue, and we're hearing, regulators at the state and federal level very concerned about privacy, including healthcare. There had actually been an FTC enforcement action previously against Google related to representations it made to consumers about its use of data that it collected. Recently, though, just in the last week, two organizations, the Electronic Privacy Information Center, known as EPIC, and another one called Accountable Tech, essentially they wrote a letter to FTC, and they said that FTC should enforce Google's promise, which it made after the Dobbs decision, that it would not retain location data about consumers who seek reproductive health care, including who visit abortion clinics or seek care at abortion clinics. Google had indicated it would delete those entries from its location history soon after the visit, is the quote, and they pledged to extend that courtesy to other locations, identifying where a user visited, things like addiction treatment centers and domestic violence shelters, et cetera. So these organizations have actually noticed to FTC that Google's broken that promise and requested the commission to impose penalties and block these unlawful data practices. So that's fairly recent. So the FTC has been pretty active, more active in 2023 than in any other year in terms of enforcing some of these privacy issues, including in the healthcare space. The only other thing I'll mention just briefly for the sake of time, Carol, is that there is currently the proposed rule pending with the Office for Civil Rights related to amending HIPAA to protect reproductive health care. That is really aimed at a lot of the issues we've talked about during this podcast, which is to prevent access to information about lawful reproductive health care or abortion to be used against an individual who may reside in a state where abortion is not legal or where the ban would affect that person's service. So that's still pending. We expect to see a final rule in 2024. OCR has a lot on its plate right now. I would expect that potentially this would be rolled into a final rule in 2024, addressing not only this reproductive health care issue, but other issues that are currently pending with OCR.
So we will end this episode the same way we started it with. There is so much going on in this area. So Gina and Jody, thank you so much for joining me on this episode. This is a fascinating topic, and I know we'll all be watching it closely during 2024. We appreciate
Thanks
you guys
for having us.
helping.
Thank you so much.